We are starting the new topic of venue. This is a topic that falls within the same series of questions that we've been asking since we started civil procedure, and that is, where can an individual file suit? So our first question under subject matter jurisdiction was, in which system can you file? In the state system, in the federal system, or in both? So you're looking across the country and thinking systemically, which one can I file in? PJ was a more narrow or focused question, which asked, okay, if we choose the federal system, which state, the federal court in which state are we going to file? Venue is our most focused question in the same series, and that is, in which district court in the state am I going to file the suit? All right, so we've looked from federal to state, choosing federal, the federal court's in which state, and now we're in the state, especially if we have multiple districts, this can become a selection, but even within the state, even if it only has one, we still have to clear the venue issue. Unlike other jurisdictional topics we've discussed so far, venue is not constitutionally based, so all we're focusing on is the statute here. You should note that Congress has very recently amended the venue statutes, both the actual venue statute itself, the general venue statute, and has amended the transfer of venue statutes. So be very careful about any study aid that you're relying on in venue, as the law has recently changed and changed quite substantially in operation. First thing to note before we jump into the statutes is a reminder about the layout of the federal courts. And so I've put up here the map of the federal courts. As you can recall, they're broken up into circuits, which are numbered here and also designated by different colors. And also within each state, especially for states that are more densely populated, you have multiple districts. Some states, for example, Utah, Wyoming, Colorado, have only one district, and so you can see, since the state has no lines bifurcating it or dividing it in any way, it is a one district state. Ohio has two districts, the northern and the southern district, and so venue will have us choosing even between these districts, or at least will be a consideration for us. So it's not constitutional. The other aspect about venue is some terminology. The proper way to talk about venue is that it is laid in a court. So is venue properly laid is the way you describe it, L-A-I-D. I already mentioned a little bit of the makeup of the federal structure. If you're following your worksheet, there's some questions that ask you about this. And first off, every single state has at least one district. Some of them have only one. Other states may have several districts. And districts themselves may be further subdivided into divisions. So you might have the Eastern and Western Division, the Northern and Southern Division. You have to check the actual court structure. But what you see designated on this map are districts, and that's where venue is really focused. But beyond that, there are also divisions within each district. So if we look at the new revised venue statutes, one thing they've added is this new section called 1390, the scope section. And one thing that's good about this is it actually didn't really change the law very significantly. The other major section that we're going to be focusing on in this class is the general venue statute under 1391. 1390 breaks up into three separate sections. The first one basically defines that this subsection 1390, 1391, and the following sections are general venue statutes. You should know that Congress, from time to time, will create more narrow-based venue provisions for particular statutes. So you need to make sure that you check to see if there's a more focused venue statute for the type of claim you're bringing. In fact, there may be. This that we're learning are the very general ones, the kind of default venue statutes. If you have a more specific venue statute that's applicable to your particular type of claim, then that is the one you should follow. You should not follow the general 1391 provision unless there is no, you shouldn't follow it if you have a more specific provision to follow. Subsection B of 1390 has a specific exclusion for certain types of civil actions that we haven't covered in this course, but you should know is there for when you get to practice. And then lastly, 1390C just reminds us that the venue statutes here do not determine where you take a case if you remove a case from state court to federal court. If you remember back in subject matter jurisdiction, we talked about removal of actions under 1441. Removal is a more specific kind of statute, just like I've mentioned here already about venue, and it tells us that a removed action must go to the district court that embraces the state court in which it was originally filed in. This section 1390 tells us while the venue statutes here, 1391, do not dictate the choice of venue for the actual removal, that the transfer of venue statutes will actually apply after the case is removed. So for example, let's presume we have a case filed in the Franklin County State Courts here in Ohio. The removal statute under 1441 tells us that that case must be removed to the Southern District of Ohio because that is the district embracing Franklin County courts. So 1391 wouldn't apply. It would be the removal statute, 1441, that would dictate that. However, once we get to the Southern District of Ohio, we are able to transfer a venue under the transfer of venue provisions that we're going to be studying in our next class after this one. So for this class, we're focusing primarily on 1391, and I want you to focus on sections B, C, and D. You can skim through the other sections, but they're not as germane as these sections for our purposes. Right, section B, you're going to go through this section in detail after you listen to the recording. I want you to complete the hypotheticals that are in the worksheet here, but what I want to do now is just give you a little bit of pointers on reading this statute and trying to see how the sections relate. So if you look, this says venue in general. It means it's where the civil action may be brought. It's just the general command of when venue is proper. It has 3 separate sections. They're all designated by the word or linking it, which may make you think at first blush that all 3 are equally places in which you may find a venue to lay generally. However, if you read with a little bit more detail in subsection 3, it says, if there is no district in which an action may otherwise be brought as provided in this section. Let's focus on that for a second. We can't find any district, no district, where it may be brought as provided in this section. So what that means is, in this section we have 2 other places for venue, under 1 and under 2. So 3 is telling us if you can't find a district where the action may be brought under either 1 or 2, then you may go to 3. So while you see the word or linking these 3 together, these 3 sections, the first sentence of section 3 designates that it is to be treated as a fallback provision. In other words, you don't go to section 3 unless you can't find venue under 1 or under 2 anywhere. There's no district anywhere where we could find 1 or 2 to work. It's a fallback provision. And be clear about this. It means there's no district in which you'll find 1 or 2. That's the only reason you can go to 3. It's not a provision saying, I'd really like to file in the Southern District of Ohio, and it doesn't work for me for these defendants under 1 or under 2, so I'm just going to choose 3. No, it's that I can't find any district anywhere, then I can go to 3. So really we're focusing on 1 and 2, which are the 2 different types of venue generally, and 3 only if we can't find anywhere under 1 or 2. So it's a pretty narrow fallback provision. Right, let's look at 1. If you skim through the language in 1, it talks about resides. Any defendant resides. So if you look further in the statute, there's 2 other definitions of residency under C and under D. So they these two sections, C and D, help define for us how we're going to look at residency of defendants as that's defined under B1. So keep that in mind. B1 is about residency, but there's going to be further definitions in C and D for residency. We'll get back to those in just a moment. Let's look now at subsection 2. It says a district in which a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of the property that is subject of the action is situated. So we've got residency and we've got events giving rise to the claim. So those are two basic grounds, and you'll answer some hypotheticals trying to apply those in a moment. When you read through these in more detail, keep that in mind. Section 1 and 2, the primary sections, residency, events giving rise to the claim. 3 is the fallback. A couple notes about residency under C. We've got 3 sections here in which we're going to see different definitions of residency. Section 1 applies to persons. And remember, note it includes aliens who are admitted for permanent residency in the United States lawfully. Section 2 talks about entities, so not natural persons, entities like corporations and partnerships. And the one thing I want you to keep in mind when you read this section, and this has been very much changed in the most recent iteration of 1391 that just came from Congress in 2011, it designates different ways of treating residency if the entity is a defendant in the suit or if the entity is a plaintiff in the suit. So make sure that you think about that when you're looking to this provision. The third section is a separate one, and it's unique now to the new modified 1391. It talks about when you find a defendant who is not a resident in the United States. So who might that be? Well, that includes aliens who are not lawfully admitted for permanent residence. They're not a resident in the United States. It also, according to legislative history, specifically includes are U.S. citizens domiciled abroad, because they're not residents in the United States. So they're not aliens, they're U.S. citizens, but they have a domicile abroad, therefore they're not a resident in the United States, and they would fit under this third section. So natural persons, entities, and people who do not reside, or any defendant who does not reside in the United States. The last one to take note of, and I want you to think about this when you read through it with more detail, is the residency requirement, or listed under D. This specifically applies to corporations. It also specifically applies when a state has a multiple district setup. So not like Utah and Wyoming with one district, but states like Ohio that have more than one district. It's a special rule that's applied to corporations when there's more than one district in the state. And so it only fits then, but it's important to know. I want you to know right away there is a fallback provision within this section. So, and you'll see it right here in the last sentence, if there's no such district. So this is to be read internally into section D here. You want to find this last clause when you're reading this for on your own for more clarity. Read the first part and then realize there is a fallback provision if you can't find a district that fits the test that's here for the corporation that lives or that resides in a multiple district state. Then you've got a fallback, okay, in this last clause. All right, so what I want you to do is look at the hypotheticals in the worksheet, work on those on your own. You don't have to submit your worksheet prior to class. We will be covering them in class, but I expect you have given it your best effort to go through before class. Thank you very much.